Hello students. This video lecture is an initiative taken by Shetvidya Mandir Junior College of Commerce and Science. It is for 12th standard SP students. And today we'll start with our fourth chapter, Issue of Debentures. Students, this chapter will explain us the various provisions, rules and regulations which a company or an Indian company has to follow whenever they are issuing debentures. Companies prefer issuing debentures to raise funds as they can be repaid after a long period. A company issuing debentures has to follow with the provisions of Companies Act 2013, Companies Rule 2014 related to share capital and debentures, and various regulations of SEBI. Depending on the type of debenture, company has to fulfill the following provisions. Today, we will see the provisions related to issue of debentures. Companies Act 2013, Section 17. The further two provisions and rules we'll see in next video lecture, that is related to issue of secured debentures and issue of non-convertible debentures. Act 2013. Our first point is no voting rights. Now this we have learnt in the feature 2, the feature of debentures. A company cannot issue debentures with voting rights. Debenture holders are the creditors of the company and say so they do not have any voting rights except in matters affecting them. This provision we have seen in learning the features of debentures. Types of debentures. A company can issue secured or unsecured debenture and fully or partly convertible debentures or non-convertible debentures. To issue convertible debentures, a special resolution has to be passed in general meeting. All debentures are redeemable in nature. Students, special resolution means in a meeting, three-fourths of the vote or 75% of the vote is necessary or it should be in the favor of issuing convertible debentures. Payment of interest and redemption. A company shall redeem the debentures and pay interest as per the terms and conditions of their issue. Even this we have seen in features of debentures. Let us see the fourth provision. Debenture certificate. Company has to issue debenture certificate to the debenture holders within 6 months of the allotment of debentures. See, the provisions for issue of debentures, majority points and explanation we have seen in the features in learning the features of debentures. But it's very important to remember such facts and figures. It can be asked in true or false, fill in the blanks, or one word. Like within what period the debenture certificate should be issued or allotted, and the answer will be 6 months. So it is very important that you learn the provisions answer with proper facts and figures. Our fifth point is create debenture redemption reserve. Students, this is one of the important point. Debenture redemption reserve is also called as DRR. Company has to create DRR account out of profits of the company available for payment of dividend. That means from the date of issue, from the year of issue, not the date of issue, from the year of issue, the company has to keep aside some amount out of profits and create a reserve named as debenture redemption reserve. This money can be used only for redemption of debentures, that is payment for debentures. As per Companies Share Capital and Debentures Amendment Rules 2019, MCA Ministry of Corporate Affairs has removed debenture redemption as a requirement for listed companies and non-banking financial companies and housing financing companies. Other companies has to create DRR. Appointment of Debenture Trustees. If the company issues prospectus or invites more than 500 people, either to public or its members, company has to appoint one or more debenture trustees. Debenture trustees protect the interest of the debenture holders. The company has to appoint trustees by entering into a contract within them called as debenture trust deed. Debenture trustees are the party through whom the company deals with the debenture holder. It contains all the obligations, rights of debenture holders, powers of trustees, etc. Debenture trustees can approach NCLT. Debenture trustees have to readdress the grievances of debenture holders. That means if the debenture holders have any issues or any complaints, the debenture trustees have to listen to the complaints and sort it out. As the debenture trustees, they talk on behalf of the debenture holders. Suppose if the company defaults in repaying the principal amount on maturity or defaults in paying interest thereon, the debenture trustees can approach NCLT, that is National Company Law Tribunal, for readdressal. NCLT can direct a defaulting company to repay the principal amount or interest. Impose restrictions. When the debenture trustee is of the opinion that the assets of the company are not sufficient or likely to become insufficient to repay the principal amount of debentures, it may approach the NCLT. Students, if you remember that all debentures are secured in nature, the company has to keep their assets against the debt taken by debenture holders. It can be a floating asset or fixed asset. But if the value of assets is not to the level of debenture capital, the debenture trustee can approach NCLT. Here, the NCLT can order a company to restrict incurring further liabilities so as to protect the interest of debenture holders. That means the company it cannot raise further debt capital until they create a charge of assets up to the value of debenture capital. Punishment for contraventions of the provisions of the Companies Act. That means if the rules are not followed. If the company fails to comply, that is follow, if the company fails to follow with any provisions of the act, then the company and its officer shall be liable to pay fine or imprisonment or both as prescribed in the act. Students, we have seen 8 provisions in issue of debentures. These provisions are as per Companies Act 2013. In further video lecture, we will see the rules and regulations and SEBI guidelines for issue of debentures. Thank you.